In this video, we will discuss certain questions we selected and framed on Sale of Goods Act 1930. So, the first question, that is, state the law on the question whether a seller of goods is or is not bound to deliver goods until the buyer applies for delivery of goods. Will it make any difference if the goods are not in possession of the seller at the time of, but are to be the acquired by the seller subsequently? So, the very answer to this question we found under Section 35 of the Sale of Goods Act 1930. So, Section 35 of the Act makes obligatory on the buyer to apply for delivery of the goods, and the seller is not bound to deliver unless the buyer applies. Therefore, the section makes no distinction between the sale of ready goods and does not render an application for delivery necessary in the case of ready goods. In case of future, when the same are acquired, the seller notifies to the buyer that they are in his possession, and it is still the duty of the buyer to apply for delivery. The buyer can only be relieved from his statutory obligation to apply for delivery by an express stipulation to the company, as it was decided in the leading case, Dinakar Bhai Lalit Kumar versus Sukhdayal Kamilas in 1947 by the Bombay High Court. So, this would be the appropriate answer to question number 1. And now we'll go to question number 2, which we divided into two sections. One is A and the second one is B. So, under A, the question is what is delivery of goods and how it may be made. And the very answer that we found under Section 2, subsection 2 and Section 33 of the Act. So, delivery means the voluntary transfer of possession from one person to another, as it is provided under Section 2, subsection 2 of the Act. If a person steals another's goods, that is not delivery, because although there is transfer of possession, but it is not voluntary. Delivery of goods sold may be made in the following two ways. One is by doing anything which the parties agree shall be treated as delivery, and the second one by doing anything which has the effect of putting goods in the possession of the buyer or of any person authorized to hold them on his behalf as it is provided under Section 33. And now we'll go to the second part of question 2, that is, be distinguished between symbolic delivery and constructive delivery. And in first one, that is symbolic delivery. In symbolic delivery, there is no actual physical transfer of the goods, but something which gives the power to control such transfer if given by one person to another. And in that context of symbolic delivery, will analyze one example, and that is A sells to B certain specific goods which are locked off in a godown. A gives key of the godown to B in order that B may get the goods. This is symbolic delivery, as the delivery of the key to B gives C actual control of the place where the goods are and thereby of the goods themselves. But it must be noted that the use of the key must give complete access to the buyer to the goods lying in the godown. If after using the key the buyer cannot put his hand on the goods, there is no delivery. For example, where only the entirety of the warehouse is handed over and the other key is retained, this is no symbolic delivery, as there is no access to the goods. And now we will go to constructive delivery. Delivery is constructive, which is effected without any transfer of actual physical possession from one person to another. And in that context, we'll analyze one example, and that is A sells certain goods to B. The goods are in the warehouse of C. She agrees to hold the goods on behalf of B. This amounts to constructive delivery or delivery by atonement. Atonement means formal acknowledgement by the person who is in actual physical possession of the goods that he holds the goods on behalf of and at the disposal of another. And now we'll go to another portion, and that is question number 3. Discuss the rights of a buyer in case of delivery of wrong quantity. So, the very answer is found under Section 37 of the Sale of Goods Act 1930. So, the very answer is that the general rule is that where there is a contract for a certain quantity of goods, the delivery of more or less than the specified quantity does not constitute a sufficient delivery, and the seller who tenders less or more of the stipulated quantity cannot call upon the buyer to accept the goods, because by delivering a wrong quantity he does not fulfill his contract. Similarly, A buyer cannot call upon the seller to deliver anything short of the quantity unless he is prepared to accept the whole. Section 37 of Sale of Goods Act lays down that where the seller delivers to the buyer a quantity of goods less than that he contracted to sell, the buyer may reject them, but if the buyer accepts the goods delivered, he shall pay for at the contract rate, which is deemed to be an index of reasonable rate, where the seller delivers to the buyer a quantity of goods larger than he contracted to sell. The buyer may accept the goods included in the contract and rejected the rest, or he may reject the whole. The buyer cannot claim to accept a part of the contracted quantity or of the excess. Where the seller makes a mixed delivery, for example, delivers the goods he contracted to sell mixed with goods of a different description not included in the contract. The buyer may accept the goods which are in accordance with the contract and reject the rest, or may reject the whole. And now we'll go to question number 4, and that is, when is a buyer deemed to have accepted the goods? Mere retention of goods for 4 days, if constitutes acceptance? And the very answer to this question number 4 we found under Section 42 of the Sale of Goods Act. So, the very answer is a buyer is deemed to have accepted the goods in the following cases. So, the first one is when he intimates to the seller that he has accepted them, and second one, when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller, for example, resell. And the third condition, when after the lapse of reasonable time he retains the goods without intimating to the seller that he has accepted them. What is a reasonable time is a question of fact in each case, and these following above conditions that constitutes acceptance of the goods, as we found under Section 42 of the Sale of Goods Act. And in regards to that, we will discuss a leading case, and that is Bhagavad Saran versus Bajnath Prasad in 1950, decided by Allahabad High Court. So it is the manifest from Section 42 that the mere act of retention of goods is not enough to constitute acceptance unless such retention is continued for a reasonable time without the fact of rejection being communicated to the seller. Hence, where only 4 days had elapsed between the receipt of the goods and the filing of the suit for the amount paid to the seller and damages, it cannot be said that there has been an acceptance of the goods, and as it was held in the leading case, Bhagavat Saran versus Bajnath Prasad in 1950, why the Allahabad High Court, and now we'll go to question number 5, and that is, when is a seller of goods deemed to be an unpaid seller, and what are his rights against the goods sold? And this very answer to this question we found under section 45 of the Sale of Goods Act, and as it is provided, the seller of goods is deemed to be an unpaid seller in the following circumstances, as it is provided under section 45. One is when the whole of the price has not been paid or tendered, and the second circumstance when a bill of exchange or other negotiable instrument has been received as conditional payment, and the condition on which it was received has not been fulfilled by reason of dishonor of the instruments or otherwise, as it is provided under section 45 of the Sale of Goods Act. If the negotiable instrument is given in absolute payment of the price of the goods purchased and it is dishonored, the seller will not be an unpaid seller and will have no remedy against the goods. His only remedy will be on the negotiable instrument, as an unpaid seller has the following rights against the goods sold when the property in the goods has passed to the buyer. So, one is a lien on the goods for the price while the seller is still in possession of goods. In other words, an unpaid seller can hold the goods as security for the price before he has parted with possession of the goods. This right can be exercised only so long as the goods have been delivered to the buyer. And secondly, a right of stopping the goods in transit against an insolvent buyer after the seller had parted with their possession. And the third one, a right of resale. So, before a seller exercises his rights of resale, he should give notice to the buyers of his intention to sell. In case of perishable goods, no such notice is compulsory. The unpaid seller can, after giving due notice to the buyer, and if the latter does not within a reasonable time pay or tender the price, then resell the goods with a reasonable time. He can hold he can hold the buyer reasonable for breach of contract for any loss occasioned to him as a result of the resale. If any profits arise from the resale, the seller is entitled to keep them. So, in this part, we have discussed five selected important questions on sale of goods Act 1930, and in our upcoming video, we would like to discuss those rest questions that we have selected under Sale of Goods Act 1930.